So you want to pass your Texas state exam and your national? Well, stay on board because that's what we're reviewing today. Questions and answers explained. So we're going to get with it right away. All right, so we're starting out with, shoot, I lost focus here. 1311, yes, that is correct. Okay, we're starting with Texas State questions today in request of one of our attendees, Cindy. So she's getting ready to take her exam. So be patient, those of you that are in other states, you can come back like around 6:45 or so, 7 o'clock, in order to get on the national. And at any time, fast forward because the class is designed to help students answer during the live so that I can help direct them in the right direction, explain the answers and the questions. And if they incorrect answer, then I go into a little bit more detail, sometimes even Google it. Okay, and I invite you to participate. Type your answer question number on the chat and the letter answer. And I would ask if you could watch on YouTube instead of on Facebook. Because those analytics are important on YouTube. Should you become a YouTuber, you'll know. All right, number 11. Let's get it a little bit larger for us. Okay, Texas State questions. Which of the following constitutes practicing law without a license? Good evening, Cindy. You asked and you received. This is one of my loyal attendees that asked if I could start with Texas State because she's taking her exam tomorrow. Okay, so which of the following constitutes a practicing of law without a license? A, licensee completing lease blanks in a lease that was written by an attorney. B, an agent completing a promulgated contract. C, a licensee completing the blanks in a contract prepared by a principal. Or D, a licensee altering a lease clause at the direction of the principal. You're very welcome, Cindy. Type your answer in the chatty chat, please. So today, it's not showing up on Facebook, quite not. Okay, so the answer here, nobody answering? The answer is D, a licensee altering a lease clause at the direction of a principal. Okay, that is to be done by an attorney. We do not alter clauses, okay? Because that changes the contract and we are not attorneys. So 1311 is D. Okay. It is streaming. Wow. Is anybody having issues on the internet? So Texas State questions and number 11 is D. All right, number 12. Which of the following best characterizes trust funds? Okay, trust funds. A, tenant security deposit. B, a rent check paid to a landlord. C, an unearned fee charged to a tenant. Or D, any money held on behalf of another. Yeah, I need to practice my own instructions. Type the question number and the letter answer. I typed in just the letter answer. All right, so far I've got 13, 12D, D, and yes, the answer is D. Okay, any money held by on behalf of another. Hi, Jaylene. Hi, Ruth. Very good. All right, number 13. No national today. Yes, the national. I mentioned it early in the class. It'll be at the end on the second half of the review or the prep class. Okay. We've got Cindy requested that I start out with state, and so that's what I'm doing. We almost always start with national because I have students from throughout the United States. So national comes later. Number 13, when a home buyer gives a broker an earnest money deposit, okay, a home buyer gives a broker an earnest money deposit, the broker is bound to do what? A, return all funds upon request. B, comply with fiduciary duties. Oh, sorry about that. Owed the seller. C, abide by the terms of the sales contract. Or D, immediately deliver the funds to the seller for depositing. Type your answer in the chat. Oops. Typing the wrong answer. No participants today. What's going on? The answer here is abide by terms of the sales contract, letter C. 1113C. Okay, because the money, earnest deposit that's delivered to a broker does not go to a seller. Okay, it goes to the escrow officer, to the title company, to the escrow officer could be an attorney, right? And unless the buyer and the seller agree that we are releasing the money, the earnest deposit, the earnest money to the seller, then we follow those written instructions. Otherwise, we follow what the contract states. So the answer was 13C and 12 was D. Okay. All right, number 14. A sales agent receives a security deposit. And sales agent, that's also realtor, right? Receives a security deposit on a lease. Well, let me rephrase that. A realtor is a professional that pays their local MLS dues, the state association realtor dues, and the National Association of Realtors. That is a realtor. A sales agent may not be considered a professional if they don't pay all those fees and become a member of each of those organizations, okay? Because we are professionals, but we have to pay a fee to become a professional. So 14, a sales agent receives a security deposit on a lease. What is this sales agent's proper course of action? A, deposit the funds immediately in her trust fund. B, deposit the funds within 3 business days of receipt of the deposit. C, deposit the funds in the operating account immediately. Or D, deliver the funds to the sales agent's broker for depositing. All righty, I've got ambitious students today. I was going to say realtors, right? That's what you're going to be soon. So yes, 14D is immediately deliver the funds. Deliver the funds to the sales agent's broker for depositing. Right? Because all the contracts belong to the broker, right? And the broker is the one that will have or may have a trust fund. So 1314D. Number 15. As a newly licensed broker, you receive a buyer's earnest money deposit on Tuesday morning. When is your deadline for depositing this check into your trust account? A, Wednesday morning. Okay, so they receive the earnest money on Tuesday morning. So when does the broker has to deposit into the trust fund? A, Wednesday morning, B, Wednesday night, Thursday night, or D, Friday night? So that's if it's going to be deposited into the broker's trust account, not the title company or the escrow officer. Wow, slow internet. So what's the answer for 15? Type your answer in the chatty chat. Well, the answer there is C, Thursday night. So it is 2 days, 2 business days to deposit any earnest money into a broker's trust fund. Trust account. Okay, so they got it Tuesday, so Wednesday, Thursday, that's 2 days later. Very good. Okay, number 16. Okay, that's not going to work. '16. The Jordans and the Couriers have jointly directed the broker Michael in writing to pay out the earnest money deposit to the Courier's son, Stephen, despite the fact that this action is not stated as a permitted disbursement in the sales contract. Michael refuses to disburse. Which of the following is correct? I made a comment about this just a few minutes ago, right? A, Michael must disburse the funds as directed. B, Michael must follow the provisions of the sales contract and refuse the directive. C, the principals have made an improper request and the matter must go to arbitration. Or D, the matter must be remanded to the registry of a court for settlement. Really? That's so advanced. If your answer in the chatty chat. Got me a new hat today. It was a gift to me because my earrings have a heart. So one of our neighbors saw me with those and gave me the hat that he doesn't use. Perfect, red and black. So number 16. Okay, yes, Cindy, the answer is A. I almost typed the wrong one. Thinking the right way, typing the wrong one. Michael must disburse the funds as directed. Why? Because it was an agreement in writing between the seller and the buyer. So very good. Number 17. Good job, Jaylene. A home seller makes a legitimate written demand for a buyer's earnest money deposit following an undisputed buyer default. In this case, the broker does what? A, must disperse the funds within 7 days of the demand. B, must disperse the requested funds within 30 days. C, must notify the buyer in advance of an imminent withdrawal from the trust account. Or D, must return all funds less any earned commission and marketing costs. Oh, no, it is not D. The answer here is B. Must disperse the requested funds within 30 days. So a home seller makes a legitimate written demand for the buyer's earnest money. So the earnest money is in the title company, and if both parties must sign in order to release the earnest money. So the seller demanded it because the buyer defaulted and they did not dispute it, right? It's undisputed buyer default. According to the contract, the specific performance is that they were supposed to complete it unless there was no good reason to terminate the contract or not follow through with the purchase. Therefore, right, the broker has 30 days in which to disburse the funds. We deliver money, yet don't always get it as fast. Has to go through the banking, clearing and all that kind of stuff, and waiting for all agreements. So that was 1317B. Okay, so let's see. Hi, Angela. Cindy said D, must return all funds less any earned. No. And many of us, when a transaction terminates, many of us don't charge the commission, right? We earn the commission when we have an executed contract, okay, and it goes to escrow. And even if it doesn't go to escrow, if the seller terminates, we earned our commission when we brought a ready, willing, and able buyer that provided an offer that was good. Okay. And however, many of us do not charge our clients if a transaction falls, nor marketing. Marketing is part of our business costs. So realize that when you go into, some realtors do charge it. Okay. I do not practice charging for terminated contracts, contracts that fall, or for marketing. Now, if the seller wants an exorbitant amount of marketing that's over and above what we believe is going to help, then yes, they can contribute on some of the marketing. Hello, Melanice. So the 17B was disbursed the requested funds within 30 days. Number 18. Trust fund documentation must be maintained by the broker for what period of time? So trust fund documentation, not the money, the documentation. A, 1 year. B, 2 years. C, 3 years. D, 4 years. Moving right along. Come on, get this one right. We got to keep all documentation for the same amount of time. No, the answer is D. Okay. Angela, you said C, 3 years. No, we in Texas must keep documentation for 4 years, including that type of documentation for trust funds. So the answer is D, 4 years. And there's also a 4-year statute of limitation that someone could complain on a transaction or on a realtor or broker. Okay, 4 years. And for y'all information, a lot of times the answers that have to do with numbers or how many years, they are usually even number. Every now and then it's an odd number, but they're usually even number. And another thing is when you experience that you don't know the answer, you don't know which one is correct, what I've learned from some of these prep books is, and from also studying myself, is that sometimes on multiple choice questions, if the several previous answers were all B, select B. Sometimes the same letter answer runs in series within the exam answers. Not always, okay, nothing's absolute. However, that's what I've learned and read from many authors, book preparers, test preparers, test centers. All right, number 19. A buyer and seller have a serious disagreement about the payment for repairing a defective water filtration system in the subject property. So what is the subject property? The subject property is the one that's being dealt with. The seller's home or the property the buyer is buying. That is the subject, okay, of conversation, that particular property. The buyer gives up and demands the deposit back. The seller disagrees, claims the buyer defaulted, and demands the earnest money as liquidated damages. What should the broker do? Okay. A, follow the instructions of the broker's attorney. B, pay the trust money into the registry of a court and let the courts resolve the issue. C, submit the dispute to the local board of realtors for arbitration. Or D, conform to the terms of the sales contract. So be very careful which answer you pick here. Think about it. Okay, so they have a serious disagreement. So they probably went through trying to resolve it, between the two brokers or two realtors. That didn't work. Mediation, that didn't work. Arbitration, that didn't work. It's a very serious disagreement that they can't come into a decision, a mutual decision. So if all those options work, and here the buyer gives up and demands the deposit, and the seller still disagrees and claims that the buyer defaulted. So the answer here, if mediation, arbitration doesn't work, then it goes to litigation. Pay the trust money into a registry of a court and let the courts resolve the issue. 1319B. Okay, and so conform to the terms of the contract. Okay, they are not agreeing. So the contract is no longer helping the issue. Okay, when someone doesn't want to release the earnest money, it requires a determination for both parties to agree to release the earnest money. They already surpassed, okay, what the contract says. And the buyer gives up and demands. So they ended up sending a demand letter to the title company or the attorney who is the escrow officer. Okay, because if nobody agrees, then somebody has to demand that they deserve to get the money back because the other person defaulted. But if both parties continue to disagree and they're both interacting, nobody gets the money. It could stay in escrow, stay into la la land. So that's why they're saying here, hey man, pay the trust money into the registry of a court and let the courts resolve the issue. Because these two individuals can't. Brokers got involved, title companies, attorneys, nothing worked. Oh, you chose all? That's funny. I thought you chose A or C. Okay, you chose them all, says Cindy. So 1319, yes, I already typed the answer there. 1319 is B. So think about it this way, okay? They are totally in serious disagreement about some repairs of the defective water filtration. Okay, so that is somewhat of, that is like a seller's responsibility to make sure that everything is working before they sell, and especially if the buyer has an inspection and they asked for it to be repaired. I mean, they don't have to, but then they'll need to let go of the buyer has the right to terminate and get their earnest money back. Okay, because they don't want to buy something that's not working. Okay, so the buyer gives up, arguing, disagreeing with the seller, and demands, okay, the deposit. And that is basically a demand letter that's sent to the title company or the escrow officer. And they both have, and the letter is sent to the other party. And if the other party still replies and says, no, okay, that money belongs to me, buyer says money belongs to me, mediation, arbitration aren't working, it costs money, then it goes to the court. The court listens to both sides and makes the decision. So the decision is put in someone else. And I had that happen. Oh, I already typed the answer. I had that happen in one transaction in Oregon. Nobody got the money. It stayed in escrow, and eventually that money is donated, as far as I understand. I've only happened in one transaction. And another one, I did have the buyer write a demand letter to get it. No, the seller, because the buyer went into la la land. I don't know what happened to him. Okay. So 1318B. So do y'all get it? Wow, that's weird. I typed 13B and it's 1319. If y'all understand that, write a comment, yes, no, maybe so. Because nobody answered. Well, Jaylene got it right, said B. Okay, you got it. Number 20. A license, well, let's enlarge that, because I know many individuals watch it on their phone. Thank you, Melanie. Okay, a licensee wants to sell a subdivision lot she owns. Here, or she owns. What does the licensee have to do that is any different from a non-licensee selling the lot? A, the licensee must provide current market value documentation. B, licensee must not list the property with her broker. Oh, may not list the property with her broker. C, the licensee must tell the buyers that she is licensed as soon as they meet one another. Or D, the licensee must disclose her license status in writing before signing any contract. Type your answer in the chat. You know, C sounds like the correct answer, but let's see. The actual answer is D. The licensee must disclose, right? So we usually use the word must disclose her license status in writing before signing any contract. So on the contract, so a licensee wants to sell a subdivision lot. What does the licensee have to do that is any different from a non-licensee? So when they're getting into a contract, so if the buyer comes directly to the realtor to buy it, in addition to informing verbally, it must be in writing in the contract. So just doing it verbally is not sufficient when they meet one another. The main impact is when it's in writing, okay? So salespeople are not allowed to market properties in which they have an interest without written disclosure, okay? So this is to convey that the licensee is an ostensible professional in the business and has the knowledge of transactions that is greater than unlicensed consumers. So it must be in writing. when a contract is being written. It has to say on there, there's a, one of the line items says, is a licensee a part to this transaction? So yeah, licensee is a, Texas licensed realtor. Okay. So the licensee may list with her own firm and does not need to provide over standard price or just verification. In fact, we don't have to list it on the MLS. Okay. We can just do it for sell by owner, just like anybody else. So the answer actually is D. I already typed the answer. Okay. So Melanie's, so Angela, Cindy, you both chose C because it says the licensee must tell the buyer that she is licensed as soon as they meet. Okay, so you tell them when you meet. And then what? What if you write a contract? Does it have to be in writing, right? Anything to be enforceable must be in writing. CYA goes to court, must be in writing, except for a lease less than a year. So keep that in mind. 3020D. Okay, you all got that? No, we don't have to provide current market value documentation to a buyer. If they didn't ask for it and they make an offer, it's not a must. Okay? No, Bailey. Sorry, Bailey eating cat food. She already had her din. So that's not a must. This is where I mentioned, be careful with the word must, always, none, never. Those are usually trick keywords. In this case, 3 of them have the word must. Okay, so more than likely it is one of those. And but the licensee must disclose and in writing in order to be enforceable. Got it? Got it. Very good. Always think about that. What if it goes to court? Is verbal sufficient? Number 21. A sales agent maintains a website where listing information is protected by a password. Nowadays, right, if we want to get information on the net or on a website or, some other things, if we want it, just, put in your phone number or your email and your name, right? And we'll send it to you. So a sales agent maintains a website where listing information is protected by a password. In this instance, such listing information is considered what? A, advertising subject to regulation. B, website advertising subject to identification requirements. C, not to be advertising due to the password protection. Or D, website scraping. All right, y'all are doing good on that one. Yes, the answer is C, not to be advertising due to the password protection. So, nobody answered. Everybody got it right. Okay. B, it says you have to have a subject to identification requirement, like, your driver's license or passport or something. Usually that's not required, right? Okay. So number 22. Which of the following would not be considered advertising? A text message to a friend to list her property. B, a billboard message to the general public. C, a phone message to a client. Or D, an email to prospective clients. So which one would not be considered advertising? 22C, awesome. That was an easy one, huh? Very good. Number 23. Is the pace that I'm going okay, or should I go faster? I don't want to go slower. So some people ask that I go faster. Number 23. One critical requirement of licensee advertising. It's okay. Thank you, Jaylene. One critical requirement of licensee advertising is that it A, identify the name of the broker, B, identify a specific property, C, refrain from using the broker's assumed name if it is not registered, or D, avoid subjective, exaggerated descriptions. Thank you, Angela. You think it's okay. So what would make it good? So what could I do to improve to help you out? So yes, the answer is A, identify the name of the broker. I mean, y'all can make suggestions if you like me to go faster, explain less, go through, more questions in a shorter time. Jump up and down, make y'all laugh, be real serious, be monotone. I don't know, that's not me. All right, so identify the name of the broker. Always, unless you are the broker and you hang the license in your own broker office because you are the brokerage office, right? Even if you're a broker and you're hanging your license with somebody else, then we disclose the broker that we are associated with. The fact that we get our own broker license doesn't mean that we don't disclose our own broker. Okay, number 24. A broker stops using a registered assumed name. What must the broker do to comply with law? A, notify the commission within 15 days. B, notify the commission within 30 days. C, register a new assumed name within 30 days. Or D, run a public notice for 7 days at the broker's expense. Whoa. I don't think broker's going to like that. Okay, come on, type your answer in the chat. See why I like to have you repeat questions over and over. I've done these questions before. Okay. So when we do them over and over, then we'll know the answer like that. We understand it and we know the things that are numbered. The answer is B, notify the commission within 30 days. Okay. Okay, so a broker stops using a registered assumed name. Make sure you notify, within 30 days, okay, to comply with law. So very good. Yes, you all did awesome. Okay, number 25. In the meantime, I got to take a sip of water. Oh, that's refreshing. Okay, 25. Internet advertising requires disclosure of the advertiser. A, unless the user is employing the medium of social marketing. B, on the homepage of the site. C, on each page of the HTML document. Or D, in the URL of the ad. So when you watch advertising on the net, where do you see their advertising information, internet advertising? Oh, you were answering 24. Okay. Type your answer in the chat. Come on, come on. The answer here is C. On each page of the HTML document. not just on the home page of the site. Because sometimes individuals may not go to the home page, right? They're going to go to other pages. Not every link always goes to the home page. Okay, number 26. Advertising, including internet advertising, may not mislead the public. In that regard, which of the following would be considered deceptive, misleading, fraudulent? A website that with an excessive number of listings on it. B, an ad stating that the sales agent ran the business like real estate professionals are supposed to. Well, how are they supposed to? C, a directional sign to an open house that was pointed in the wrong direction. Or D, an ad directed at buyers for exclusive representation that stated the buyer may not have to pay commission. So which one is deceiving, deceptive? Okay, one answer. Jaylene, you're on the ball. Come on, Cindy. The answer is B. An ad stating that a sales agent ran the business like real estate professionals are supposed to. Real estate is our own independent business. Okay, we run it the way we see fit, how we do business. Every individual is different as long as we follow the rules and the laws. Okay, a directional sign to an open house that was pointed in the wrong direction. No, that's not deceptive. That can happen accidentally. I've seen it happen. Okay, that's not intentional. It's accidental. We humans, we make mistakes. So the answer is B. So what other answers? That was it. C. Okay. All right. Number 27. Okay. Sorry, I've got a whole bunch of stuff on my mind. I've got grandkids tonight. Oh, come on. 27. Oops, wrong way. Okay, number 27. A residential market has fallen on hard times. To make more deals with buyers, a licensee advertises an offer to rebate portions of their commission to any buyer in order to make prospective purchases more attractive. Given this scenario, which of the following applies? A, the ad must disclose that the rebate is subject to the seller's approval. B, the rebate must be made in cash before closing. C, the ad must identify a dollar limit of the rebate. Or D, the licensee may not make this offer as rebates are not legal. So is it us who do that when we're representing a client, or is it our client? Okay, C, I've got an answer of C. Anybody else? Okay, all right. You changed it to A. Very good. Yes, the answer is A. The ad, The ad must disclose that the rebate is subject to the seller's approval. Because the sellers are paying the majority of the time are paying the commission. Okay, occasionally a buyer will do that, but that's when it's a for sale by owner, where a for sale by owner doesn't want to pay the commission, then somebody's got to pay for it, right? We don't work for free, or at least we shouldn't. Okay, unless it's a major repeat client. and we can do something pro bono, but they also understand if they're major investors. So the answer is A. The ad must disclose. So to make more deals with buyers, a licensee advertises an offer to rebate portions of their commission to any buyer in order to make prospective purchases more attractive. Well, that depends on the seller approval. Right, number 28. A sales agent advertises that they can consummate more closings in less time than any other volume agent in the market. You'll even hear that on the radio advertisements. The ad lists four such competitors listed in rank order of their prior year sales volume. Which of the following applies to this advertisement? Okay, so do we need proof to make such a disclaimer? I mean, such a advertisement or not? A, the ad is illegal since it rank orders direct competitors. B, the ad is illegal unless it discloses what the ranking is based on and the source of the data. C, the ad is acceptable provided that the parties on the list approve the ad. Or D, it is deceptive since sales volume is not relevant to an agent's proficiency. Okay, so far I've got a B. Anyone else? Yes, the answer is B. Very good, Cindy and Jaylene. The ad is illegal unless it discloses what the ranking is based on and the source of data. Now, I've heard some radio commercials where the realtor is not comparing. They just say, we can close the deals in 30 days or less or buy your property. There's different requirements that have to be met in order for that to happen, that the seller has to commit to. Number 29. So you answered it correctly. Okay. Which of the following is true regarding office regulations for brokers? Office regulations for brokers. A, in-state resident brokers must maintain a fixed office location. B, additional branches need not have an office license provided it is within the same market area. C, non-resident brokers must maintain an in-state office. Or D, if a broker changes locations, the broker's license transfers to the new office location. Okay, and that, well, never mind. I'll wait until y'all answer. Excuse me. Good night, Bailey. Okay, the answer there is very good. A. An in-state resident broker must maintain a fixed office location. Now, that fixed office location doesn't have to be a brick and mortar office. It could be a post office box, okay, at, these UPSs and others, right, that can provide service and take information, documents, and money. Good night. A friendly neighbor picking up the dog I borrowed. Okay, so y'all did good. Awesome. All right, number 30. It's going to be a little small, but a buyer, well, if I take it to the next screen, Let's see. Okay, that's better. A buyer signs an offer to purchase property. At this juncture, the licensee is required to disclose which of the following. Okay, so buyer signs an offer. A, so licensee must do what? Required to disclose which of the following. A, that the price agreed was developed without coercion or market collusion. B, that the buyer should get title insurance or a title abstract examination by an attorney. C, that TREC requires the buyer to obtain property inspection. Or D, that the buyer must be pre-approved to satisfy the contract's financing contingencies. What if there is no financing? All right, ladies. 30B. Okay, that the buyer should get title insurance or a title abstract examination by an attorney. Okay. All right, so we've done 20 state questions. So we're going to shift to national for those that still need to do national. So in the meantime, let me know if you have any questions that I may be able to answer. My lighting doesn't look so perfect today. Well, maybe with the winter is coming, it seems darker. All right, here, let's see. Any questions? For those of you taking your exam, I wish you the best and that you get an easy exam. Okay, sometimes that happens. You're welcome, Cindy. And there was Jaylene saying, good luck tomorrow, Cindy. Awesome. Very good. I love it when y'all participate and wish each other good fortune. So national, we're starting with 416. Okay, and if you happen to follow along with this book, the answers are on page 254. And that's on the descriptions. So again, you all remember, you are able to buy some of these books. I do have the links down in the description. And there are prep books that I have reviewed and students have recommended that are great for studying questions and answers and that have a summary on the material that you have studied in the 6 courses. Okay, if it's for Texas, some other states might be different. Some states have more questions and more classes. Some have less. Every state is a little bit different. Okay. However, you can, some of these books are purchased, are written for the majority of the states. Some of them are limited, 25, 30 states. So, find one that works for you. If you like how these work, I love books that have questions and answers, also summarizes, has math, and some of them also have vocabulary. Okay, number 15. So this is now national questions that applies to all 50 states. In some states, the national and the state is all on one exam, right? In Texas, we have 2 separate exams, one for national and one for Texas. Oops. Oh man. National, I can't type, don't know how to spell. National question. So it's almost at the hour. Okay, ready to go. Number 16. Implied agency arises when A, an agent accepts an oral listing. B, a principal accepts an oral listing. C, a party creates an agency relationship outside of an express agreement. Or D, a principal agrees to all terms of a written listing agreement, whether express or implied. So implied agency. It's a normal understanding between, a relationship, working together. We say, oh, we're going to go look at property. Oh, we're going to work together. So let's see, I've got C, D, D. Okay, the answer is C. Implied agency is C. A party creates an agency relationship outside an express agreement. So it can be implied. We're going, shopping for houses, or, I went and visited your home and there was no disagreement. It's implied that we're going to be working together. So 416 C. So it's an agency relationship can arise by implication, intentionally or unintentionally. Implication means that the parties act as if there were an agreement. Okay. For example, if an agent promises a buyer to do everything possible to find a property at the lowest possible price, and the buyer accepts the proposition, there may be an implied agency relationship, even though there is no specific agreement. It's like, okay, I'm going to represent you and you're going to be loyal to me, right? They didn't say that. It's just implied. They're working together. Not always the case. So that was 16C. Okay, do y'all get that? Let's see, I had 2 Ds. A principal agrees to all terms of written listing agreement, whether express or implied. No. So look up the definition of implied. It's an activity between the two that could, display that, hey, I'm your realtor or you're my client. There's no disagreement, no opposition. So it's implied. It's an understanding. Number 17. An agency relationship may be involuntarily terminated for which of the following reasons? A, condemnation of the property. B, mutual consent. C, full performance. Or D, renewal of the agent's license. So an agency relationship. Okay. Involuntarily terminated for which of the following reasons? So involuntary means they didn't really want to terminate it, okay, but they were forced into it. What could cause that type of situation? Man, I'm not doing very good here typing my answers. Oh my gosh, I'm all out of whack today. Luckily it's 416C and all right, A, very good. Yes. Condemnation of the property, right? It's an involuntary termination of an agency relationship. So let's say there was a property and a listing agreement, or somebody wanted to buy it. Well, that can be terminated, okay, with a realtor or other, because the condemnation is being taken by eminent domain, right? The right to take property for public use. Condemnation is the action to take over that property. So the action of taking over the property without the other party agreeing. However, there has to be true market value compensation. So, yep, all of you did great. Awesome. Okay, number 18. A principal discloses, well, let's see if I can get that larger. A principal discloses that she would sell a property for $500,000, half a million. During the listing period, the house is listed and marketed for $530,000. No offers come in, and the listing expires. 3 weeks later, the agent confides to a customer that the seller would have sold for less than the listed price. Which of the following is true? So 3 weeks later, so the listing expired. So the agency relationship between the principal and the listing broker expired. 3 weeks later, the agent confides to a customer, okay, not a represented buyer, that the seller would have sold for less. Which of the following is true? A, the agent has violated the duty of confidentiality. B, the agent has fulfilled all fiduciary duties since the listing has expired. Or C, the agent is violating the duties owed this customer. Or D, the agent has created a dual agency situation with the customer. Okay, remember, they're a customer and we had an agency relationship. So what is very crucial about an agency relationship? Yes, confidentiality. And especially, the buyer is a customer, right? They're not a client. Okay, but that is confidentiality. All right, number 19. A principal instructs an agent to market a property only to families on the west side of the university campus. The agent refuses to comply in this case. A, the agent has violated fiduciary duty. B, the agent has not violated fiduciary duty. C, the agent is liable for breaching the listing terms. Or D, the agent should obey the instruction to salvage the listing. Type your answer in the chat. All right, so far I have an answer of B. Anybody else go along with that or something else? The answer is B. The agent has not violated fiduciary duties. Why? Because what the seller is asking is against fair housing laws, right? No discrimination, no steering, no blockbusting, none of that stuff. So we terminate the relationship. Okay. All right. Number 20. An owner's agent is showing a buyer a residential property for sale. An owner's agent is showing a buyer. The buyer notices water stains on the foundation walls and floor and informs the agent. The appropriate course of action for the agent is to do what? A, immediately contract the paint to paint the ceiling. B, immediately contract to repair the roof. C, suggest sorry. B, C, suggest the buyer make a lower price offer. Or D, inform the seller. Oh my goodness. I typed the answer already in. I click return. Yes, the answer is D, is inform the seller. Okay. Anything that we learn, whichever way we learn, we disclose to the seller. Okay, because that's who our client is. That's our fiduciary duty. For 19, I was confused on C. For 19, the agent is liable for breaching the listing term. Oh, no, no, no. We don't do something that is against, fair housing laws or anything against certain laws protecting the consumer, or that goes against any other laws, okay, of real estate or principles. That realtor did not violate any fiduciary duties when the agent refuses to comply. Okay, so Jaylene's made the comment here. 19, I was confused on C. Okay, hopefully we help unconfuse you. If a client is asking us to do something that's against an act or a law in real estate, we refuse it. We terminate the relationship. We refuse it, and if they want to continue doing business, following the rules, okay, the contract, great. But if not, hey, you know what? We don't need to get in trouble. Terminate the relationship. They're not the client for us. 21. The meaning and salient characteristics of agency relationship should be disclosed to the client. Excuse me. A, prior to completing a listing agreement. B, prior to or upon completion of an offer. C, upon the initial contact with the person. Or D, prior to showing properties. Sorry, I've got a slight cold. I'm going to turn my fan off. Oh, my goodness. All right. Yes, the answer is A. Prior to completing a listing agreement, the meaning and salient characteristics of agency relationship should be disclosed to the client. So it's an agent who intends to represent a seller or owner must disclose the import of proposed agency relationship in writing before a listing agreement is executed. For 21A. Just a comment here. It says prior to showing properties. Yes, we do talk to them about that, but the agency relationship is once we have a signed agreement, right? Either a listing agreement or a buyer's representation agreement. Uh-oh. Sorry, hold on. I accidentally disconnected my other two monitors, and I need them. Okay, bear with me while my system comes back to working function. And excuse my sniffles. All right, so where were we? 421A. Okay, number 22. When must a listing agent disclose his or her agency relationship to prospective tenants or buyers? Tenants or buyers, right? Because we can also represent, buyer tenant representation. So lot of times the buyer's representation agreements as buyer-tenant representation. Some states do help tenants. Other areas do not. We do here in Texas and San Antonio. So 422, when must the listing agent disclose his or her agency relationship to prospective tenants or buyers? A, immediately prior to the initial contact. B, upon initial contact. C, whenever substantial communication is made beyond casual conversation. Or D, immediately following any offer executed by the customer. Yes, the answer is C, Melanie's. 422C. Whenever substantive communication is made beyond casual conversation. We are on number 22. I'm sorry, I'm losing focus here. Oh, very good. Y'all got it. Y'all got it right. All right, number 23. A buyer agent or tenant representative should disclose his or her agency relationship to the owner's agent. So a buyer agent or tenant representative, buyer-tenant representation, right, should disclose his or her agency relationship to the owner's agent. A, immediately prior to the initial contact. B, upon initial contact. C, immediately prior to substantive contact. Or D, immediately following any offer executed by the landlord. So this is between realtors, right? A buyer agent with a listing agent, right? Disclose the agency relationship with the owner's agent. So this is agent to agent. All right, yes. The answer is B, upon initial contact. So when we're dealing with a buyer, it says, in the education that we get trained, is substantive communication beyond casual conversation. And it's done like, when they're finally talking about particular properties. So that's considered more substantive conversation. And then here between realtors is as soon as we interact with them, upon initial contact via phone, text, email, in person. Number 24. An agent is operating as a disclosed dual agent on a transaction. In this case, the agent, okay, remember these are national questions. A, may not represent one party's interest to the detriment of the other. B, must operate without a listing agreement. C, must be obedient and loyal to both parties. Or D, must require that the principals refrain from disclosing any material facts to them. So an agent is operating as a disclosed dual agent on a transaction. And they're not the broker, okay? It's in a state where there is dual agency. So remember I said you'll take off your seller hat and then put your buyer hat on. I should have another hat here. Okay, Melanie, so far we've got A. And yes, the answer, and Angela also A. The answer is A. Okay. May not represent one party's interest to the detriment of the other. We have an agency relationship with both. We have to represent them in a fiduciary responsibility with each one. So since we represent both, there's a lot of things that one of them tells us to the other that we cannot disclose, right? Compared to if a buyer says, hey, I'll be able to pay a whole bunch more money, but they're independent, they're not represented. We can tell the seller, but not in this case. So you don't get that answer. Okay, so in a dual agent, in a state where you can, one realtor can represent both clients, we have a fiduciary duty to both. So we have more extreme confidentiality. Anything that we know about the owner's subject property situation, their finances, or what they'll accept or won't accept, we cannot share with the buyer because we represent the buyer. Okay. Now, if we represented the buyer and not the seller, and the seller tells us that, of course, we would disclose that to the buyer. Okay. And if the buyer said, oh, I'm willing to offer a lot more for that property, but we represent both, we can't say that to the seller unless we don't represent the seller. But when we represent both, anything we hear about what one or the other can financially do or offer or wants to do or doesn't want to do, we cannot disclose. Okay, there's a stronger, more confidentiality about anything and everything that is discussed unless it's put in writing. Okay. So there are states where you can do both. I was confused when I saw detriment. Okay, so you have an agreement with a seller and you have an agreement with a buyer. So we have to represent each of them equally, okay, independently, and protecting each one of their own interests. Okay, so, how do you, so you have to, learn about negotiating, how to deal with situations like that when you're representing two parties and that you advise. Well, on certain things, you may not be able to advise because you represent both parties. Okay. So, when we represent a buyer, we're there to get the best and lowest price for the property that they want. When we represent the seller, we want to get the highest and best offer with the best terms for our seller. Well, in this case, we've got both. We know what the seller wants and we know what the buyer wants. So we're like a mediator in between. We can't encourage or discourage one or the other. Okay, so 424, very good. Number 25. An agent informs a buyer that a provision in a contract is very commonplace. After explaining the clause, the agent assures the buyer that the clause does not mean anything significant. If something goes wrong with the transaction, the agent could be liable for what? A, violating duties owed a customer. B, misinterpreting the clause. C, intentional misrepresentation. Or D, practicing law without a license. So they're saying agent informs buyer that a provision in a contract is very commonplace. Is that our place to do that? Yes, 425D. That is practicing law without a law degree, without being an attorney. Okay, number 26. When a broker enters into a listing agreement, the broker has agreed to accept which of the following? A, fiduciary and contractual obligations with the client. B, fiduciary relationships with client and customer. C, contractual obligations with cooperative brokers, or D, fiduciary obligations with the customer. So who do we represent when a broker signs a listing agreement, enters in a listing agreement with their client? So far, I've got A. And yes, that is the answer. A, fiduciary and contractual obligations with the client. That's what we are accepting. Number 27. The degree of authority granted by a residential brokerage listing agreement generally allows the agent to do what? A, create contractual obligations for the client. B, negotiate the selling price between client and customer. C, hire inspectors and other individuals to prepare the property for marketing. Or D, market, sell, and show the property. When we're representing a client, a residential brokerage listing agreement, the authority that we have is to do what? Yes, bring a ready, willing, and able buyer, right? Doesn't mean that we literally have to procure the buyer. It could be other realtors, but our marketing will attract those realtors to sell it and to show it. Okay. And we don't actually sell it, right? Our client does, because they're the ones that own it. But that's what we normally say. I sold my client's property. Well, they sold it with our marketing expertise and business expertise, negotiating expertise, to attract a ready, willing, and able buyer. So market, sell, and show the property. And basically what we're doing is, when we're marketing it, we're advertising it, we're selling it, right? We're putting the word out there, letting everybody know. Number 28. A salesperson without an oral or written listing agreement brings potential buyer to the seller. The seller says, "You can bring me buyers if you want, but I'm not paying you a commission." The salesperson then continues to direct buyers to the property. Which of the following is true about this situation? A, there is no agency relationship, and therefore the seller will owe no commission if one of the salesperson's buyers buys the property. B, an implied agency may have been created with obligations to perform to both buyer and seller and agent. C, the seller and agent have an illegal undisclosed agency relationship. Or D, the agent has an open exclusive agency listing with no commission agreement and therefore owes no fiduciary duties to the seller. Type your answer in the chat. All right, so far I've got a B. Okay, so here the answer is B. We have an implied agency that has been created, right, with the actions of bringing them buyers. And the seller is saying, "Hey, bring me the buyers you want. I'm not paying you no commission," right? But it's still implied that they can bring buyers with obligations to perform both seller and agent. So seller has to perform, right, to sell the property, because they said, "Bring me buyers." And the agent is bringing buyers to them. So they're bringing a potential buyer that is actually going to go into contract. So it's an implied agency that has been created, that may have been created with obligations to perform for both seller and agent. right? Both of them has a specific performance. Number 29. An agent enters into a listing agreement with a home seller, but then becomes too busy to professionally fulfill the terms of the agreement. To solve the dilemma, the agent assigns the agreement to another licensee in the office. Which of the following is true about this situation? A, the agent cannot assign a listing agreement. B, the new listing agent acquires the full set of fiduciary duties owed to the client. C, the new broker has to split any commission that results with the assigning broker. Or D, the original broker has to disclose the assignment to the seller. So type your answer in the chat. Yes, very good, Melanie's. A listing agreement cannot be assigned. So because we don't know that the seller is going to want to work with that new realtor, okay, we can ask the seller if we can refer them to another realtor, and then a new listing agreement, right, is created adding that realtor. So it's a seller's decision, not ours. So the agent cannot assign the listing agreement. Now, a sales contract can be assigned, okay, by an investor who, contracts on a property, puts it on hold, finds a buyer, and then assigns it. And at closing, the relationship now becomes between the seller and the buyer, and the wholesaler, the middle person, ends up getting a fee paid. All right, number 30. From an agent's point of view, the most desirable form of listing agreement is A. So from an agent's point of view, the most desirable form of listing, A, exclusive agency, B, exclusive right to sell, C, open listing, or D, net listing. So which is the best type of listing that we want to have as a realtor? We want to get paid, right? No matter what. That's correct. B, an exclusive right to sell agency agreement. No matter who procures the buyer, we get paid. Number 41. What is a multiple listing? A listing shared by a listing agent with a selling agent. B, a listing that is a listing agent delegates to a sub-agent. Oops, sorry about that. C, a listing that is entered in a multiple listing service to enable cooperation with with member brokers. Or D, a listing that authorizes a listing agent to market more than one property for the seller. So what is a multiple listing? Okay, so I think, Melanie's, you answered B. I'm not sure if you answered B for 30 or 31. Hi, Lanice. So the answer is C, a listing that is entered in a multiple listing service, MLS, to enable cooperation with member brokers. So that's what we will end up using once we become a realtor and we join our local MLS board, and we have access to everyone's listing, including those that we post ourselves. That is how realtors know what is on the market when we are professional realtors, right? Members of all organizations, local association of realtors in your state, and the NAR. Number 42. Which of the following conditions is necessary for a customer to qualify as ready, willing, and able in a context of a commissionable transaction? You're going to hear that a lot when you become a professional realtor, ready, willing, and able. So is it A, the customer's offer must be accepted? B, the customer must be legally competent to undertake the transaction? C, the customer must have a commitment from a lender? Or D, the customer must have no business relationship with the agent? Ready, willing, and able. Because remember, not everybody's going to have a lender. Yes, the answer is B, Lenise. The customer must be legally competent to undertake the transaction. Number 33. 33. Getting way ahead of myself here. Although a listing broker may delegate listing tasks to an employed licensee, the broker may not delegate the authority to do what? A, obtain and distribute compensation. B, provide cooperating brokers with information about the property. C, advertise the property. Or D, inspect the property for hazardous substances. So although a listing broker may delegate listing tasks to an employed licensee, a person that's licensed, they're a realtor, but they're also an employee. The broker may not delegate which of those authorities. Type your answer in the chat. The correct answer is A. Obtain and distribute compensation. So that responsibility cannot be delegated to an employed licensee because the compensation, the commission comes from the broker. It's paid through the broker. It comes from the clients and pass through the broker after they keep their percentage, unless once you're capped and you're getting 100%, or you're with a transaction brokerage. All right, number 34. Agent Peter has an open listing with Frank. Oh, it's Melanie's. Lanice. Oh, I should have caught that. Lanice Interiors. So check that out. So Melanie's is Lanice Interiors. Awesome. You have a business. So Agent Peter has an open listing with Frank. Paul is Peter's broker. Agent Perry's customer buys Frank's house. Patrick has a commission agreement with Frank. Who is most likely to be compensated in this scenario? So Agent Peter represents Frank. Paul is Peter's broker. Okay. Agent Perry, customer, buys Frank's house. So that's the buyer agent. So Patrick has a commission agreement with Frank. Okay, so who is Patrick? Who is most likely to be compensated in this scenario? A, Peter, since he has a written listing agreement. B, Paul, since he is Peter's broker. C, Perry, since he found the customer. Or D, Patrick, since he has a commission agreement. So Agent Peter has an open listing, okay, with Frank. So Paul is Peter's broker. All right. So Agent Perry's customer, not represented, buys Frank's house. Okay, so another realtor brings a buyer to Frank's house where Frank has an open listing with Peter, agent. So Patrick has a commission agreement with Frank. So there's another realtor that has an agreement with Frank. The Frank is the one that has an open listing with Peter. So who is most likely to be compensated in this scenario? Peter, since he has a written listing agreement. Paul, since he is the Peter's broker. Perry, since he found the customer. Or D, Patrick, since he has a commission agreement. Yes, the answer here is C, Perry, since he found the customer, right? So Agent Perry brings a customer to Frank's house. And it's an open listing, right? 434. So 434C. Oops. Dang it. All right. So remember, you can have an exclusive agency agreement where the owner isn't going to pay unless their realtor procures the buyer. So here, that owner is getting the best of all worlds. He's got a written listing agreement and that realtor can market the property. However, if he doesn't bring the buyer, he's not going to get paid. Okay. So since Patrick didn't bring the buyer, he's not getting paid. Perry is the one that brought the buyer to Frank's house. So that's who Frank is going to pay. Well, going to pay the broker, right? The answer was C, 434C. Yes, okay. Number 35. If an agent has an exclusive listing to sell a property, okay, exclusive listing to sell, and the property is then taken by eminent domain, what is the status of the listing? A, the seller's obligation under the listing are assigned to the agency that takes the property. B, it becomes a voidable contract. C, the commission clause of the agreement is canceled. And D, it may be terminated against the agent's will. Remember, eminent domain, right? Is the right to take property for public use. Yes, the answer is D. It may be terminated against the agent's will. Okay, because the seller now has to sell it, okay, must sell it to the city or the county, whoever has the eminent domain right. Okay, and if he doesn't, they're going to go to court to condemnation, right, to take over the property with compensation that meets the current market value of that property. Okay. Awesome. Okay, you all. We're calling it a night. Okay. And I've got a whole bunch of other things to do. Plus, I'm struggling with my sinuses here. So we did we did 15 national and 20 state questions for Texas. Okay, because I think we started on, what did we start here? Yeah, we started with question 16, 25. Oh, actually, we did 20. So we did 20 and 20. All right, we did good. So any questions before we call it a night? So remember, if y'all are watching on YouTube, which I would love for you all to continue watching from now on, is please tap that subscribe button if you haven't already. Click that little bell so you're the first to get notified every time I go live. And give me some thumbs up, right? Send me some love and encourage me. It'll encourage me to continue doing more videos. Plus, the more thumbs up, comments, and subscriptions I get, the more it helps the analytics in YouTube. So thank you very much for attending. Love you all. I wish you all the best, okay, on preparing for your examination. Take breaks, rest, relax, get your mindset good, okay? Don't doubt yourself. Don't worry about the future. Think about what you're doing today. Don't fear what's going to happen tomorrow. Work on what's today. I know it's easier said than done, okay, because I experienced it myself. However, the better mindset you have, and that will help you prepare better for the exam. Try to learn the material, repeat it over and over, and have confidence. Trust yourself, and then go take the exam. Should you not pass, don't be so hard on yourself. You didn't fail. Just means you need to do a better way of studying, do a better job of studying, organizing yourself, making a plan, and working on your attitude, your mindset, your health. Whatever is getting in the way must be taken care of in order so that you have a clear mind to understand the material and be able to answer those questions. Okay, so don't be so hard on yourself. So hopefully this will be a business that you are going to enjoy once you pass your exams. Remember, I am a realtor with eXp Realty, and I am looking to bring on some realtors to eXp. And if you're interested in learning about our company, eXp Realty, our virtual online company, just like everybody went pretty much online during COVID, right? So we're the Amazon of real estate, right? So much is referring to Amazon. So until next time, you all have a good evening. Catch you all later. I passed. Yes.